Mr. Smith, you've said several times in your deposition that you believe that the facts and the law, your interpretation of the law, would lead to a conviction of President Trump. Is that correct?
Yes.
And did you believe that same thing, that your interpretation of the law, your reading of the law, would have resulted in the conviction when you went after Virginia Governor Bob McDonnell back in 2014?
All right, buckle up, political junkies. We're diving into a clip that perfectly encapsulates the current state of political theater. Representative Cline is trying to poke holes in Jack Smith's record, hoping to discredit his investigations into Trump. But sometimes when you dig, all you find is more dirt. On yourself.
Did you believe it at the time?
I did believe.
And ultimately, you got a conviction in lower court, but that was overturned by the Supreme Court, correct?
Yes, the Supreme Court changed the law on what constituted an official act, and
Actually,
as a
that's
result,
incorrect.
that conviction was overturned.
That's incorrect. They applied the law, and they said in their ruling, our concern is not with tawdry tales of Ferraris, Rolexes, and ball gowns. It's instead with the broader legal implications of the government's boundless interpretation of the federal bribery statute. A more limited interpretation of the term official act leaves ample room for prosecuting corruption while comporting with the text of the statute and the precedent of this court. They accused you of using a boundless interpretation of the federal bribery statutes.
Okay, hold up. Cline is trying to hang Jack Smith out to dry here, bringing up a Supreme Court decision from years ago. It's like blaming a chef because the recipe standards changed after they cooked the meal. The Supreme Court didn't say Smith was wrong on the facts. They literally changed the legal definition of official act. That's the law evolving, not a prosecutor's failing. Trying to spin this as boundless interpretation is just a transparent attempt to muddy the waters.
Now, did you believe when you went after John Edwards that your interpretation of the facts and the law were correct and that you would convict John Edwards of corruption?
Yes.
But in fact, that case resulted in a jury deadlock on 5 charges and acquittal on another charge. Is that correct?
That is my recollection. That's correct.
Let's move on to the court's interpretation of your gag order requests. Mr. Smith, America was founded on the principle that the government doesn't silence political speech, in particular speech before it happens. You sought a prior restraint against President Trump without a single violation of pretrial release. In fact, there was no real-world harm that you could articulate justified giving the federal government the power to silence him as a presidential candidate, was there?
The court granted those motions and found that the prosecutor did not have to wait until someone was harmed to make such a motion.
Actually, the request was rejected when the case was actually, when you actually were not able to, it was restricted, correct? The gag order was restricted, correct?
Well, we filed for an order in the district court. The district court granted an order. Mr. President Trump appealed that order. The Court of Appeals absolutely agreed that there was a basis and that the threats to witnesses that came from the targeting by Donald Trump were real and that we had a duty to protect them. You are correct in that the Court of Appeals narrowed the order, so the order covered witnesses, court staff, the judge, and my staff. The difference was that it didn't cover me anymore, which I was fine with.
Did you have any evidence that President Trump's statements about the cases against him intimidated witnesses or prevented them from coming forward?
I had evidence that he said, if you come after me, I'm coming after you. He suggested a witness should be put to death. The courts found that those sort of statements not only deter witnesses who've come forward, they deter witnesses who've yet to come forward.
But you weren't able to identify a single witness who didn't come forward because they were intimidated by President Trump.
We had extremely thorough evidence that his statements were having an effect on the proceedings that is not permitted in any court of law in the United States.
This is a classic gotcha attempt that completely misses the point. How do you quantify a witness who never came forward because they saw the chilling effect of Trump's rhetoric play out? When a former president attacks judges, prosecutors, and their families, people get scared. You don't need an explicit "I was intimidated" statement for the intimidation to be real and damaging to the justice system. It's about protecting the process, not waiting for someone to become a martyr.
Don't you think it's a pretty low bar to clear if you're trying to silence a candidate for president? I mean, if you can't identify a single witness who's intimidated, that maybe you should reconsider the gag order?
Both courts upheld the orders. It is not incumbent on a prosecutor to wait until someone gets killed before they move for an order to protect the proceedings.
Did anyone on your team raise concerns that this expansive gag order you were seeking would infringe on President Trump's First Amendment rights?
My recollection is that we, of course, discussed First Amendment issues regarding this application because I and my staff respect the First Amendment, but the First Amendment does not allow one to make statements that interfere with the administration of justice in a judicial proceeding. My interpretation was supported and agreed upon by the district court and the Court of Appeals in terms of the phenomena of the statements being made, targeting individuals, causing threats to happen to them. I would also add, sir, that in the days after Donald Trump made some of these statements, the district court, in this case, received vile threats to the district court's life. In that environment, I felt a duty as a prosecutor to make that motion, and I make no apologies.
And
Boom. Jack Smith just dropped the mic. I make no apologies. That's the sound of a prosecutor on solid ground, despite the political theater. When death threats are hurled at judges and court staff, any responsible prosecutor has a duty to act. This isn't about silencing political speech. It's about preventing a circus from becoming a bloodbath. The First Amendment isn't a get-out-of-jail-free card for inciting violence. The hypocrisy is just chef's kiss.
the court stayed that motion on August 3rd, 2024.
So, what do you think? Is Jack Smith a rogue prosecutor, or is he just doing his job in a truly unprecedented political climate? Let us know in the comments below. Don't forget to like this video, subscribe to our channel for more breakdowns, and hit that notification bell so you don't miss our next deep dive into the wild world of California politics. Stay engaged, stay informed. I'll see you in the next one.
I yield back.